Okay, guys, we're going to go ahead and wrap up our tort and civil law lecture with this one. Now, all this one is going to be, I'm going to wrap up the third type of tort or civil case, which is strict liability cases. Now, I do just want to explain very briefly what it is, where in a strict liability case, the defendant is involved in a particular situation that is considered to be so dangerous that there's serious risk of harm really at every point within the activity. So at least for kind of basics, I use the idea of when a demolition company is going to be imploding a building, there's simply just so many ways for things to go wrong and for someone to get hurt or even killed that they are considered to be a strict liability suit, because it's just so complex and it's so dangerous that even no matter how many safety steps that company might take, they can still very easily be held liable. In fact, the liability is going to be imposed even without necessarily proof of fault. What that's saying is basically they can have all sorts of safety measures, and many of them do have excessive safety measures, but it still doesn't make them clear. It doesn't make them impervious to a lawsuit. What they're doing is so dangerous that, in fact, they're almost set up for a lawsuit. And I had someone ask me in years past, so I kind of want to answer this. In a certain way, they are kind of guilty until proven innocent. That's what they're doing is so dangerous that, yes, lawsuits can come really very easily with this. So even if even if that company takes all the precautions, they can still be sued if someone gets hurt or someone gets killed. Now, I can say this because for construction companies, they do kind of have some difficulties as far as protecting themselves from lawsuits, not only just from their employees, but from surrounding areas as well, from people in the area. So they do put up that protective fencing around construction sites to potentially keep people out of the way. But there are often times where they're working in such tight spaces that they simply can't protect everyone in a way that is feasible for what they're doing. So I do have an example of in downtown Denver. This was a few years ago. A friend of mine was actually walking underneath a construction site as they were working on, I believe it was the 10th floor of a tall building in Denver, and something fell from the construction site and actually hit her in the shoulder. She wasn't seriously hurt, but I forget exactly what it was, but an item falling from 10 stories and hitting her in the shoulder did actually require a hospital visit. So she went to the hospital, told them what happened, and they said, well, just be certain that you get a hold of that company because they're the ones that are liable. The company said, yes, it was our fault. We're not even willing to go to court. We want to just go ahead and settle this right now. And she did sign a settlement because the company knew that they were going to, if they went to court, they could be sued for a ton of money. So they decided to settle out of court very early on. This is what a lot of these companies will do because the law is actually set up very much against them. Now, there are going to be some other areas of strict liability. Some are dealing with companies and some can even deal with private citizens. So the first one I do want to give you is dangerous animals are considered a strict liability suit, where even just simply having a dangerous animal makes you liable for what that animal does. Now, I can use some examples like this one on the right here. Maybe you remember this or not, but this was a magician act in Las Vegas years ago called Siegfried and Roy. They are going to be in charge of multiple dangerous animals, including tigers like this one here. One of these tigers attacked one of these men and did very serious damage to him, put him in the hospital for weeks and months, if I remember correctly. But it was not someone else that was part of the company that was attacked. It was one of these performers. So simply by having this dangerous animal, you're liable for what that animal does. Now, of course, it's not necessarily just owning tigers. It can be owning just a dog with a bite history. If a dog has bit someone in the past, that makes them a strict liability dangerous animal. So if they bite someone in the future, then yes, the owner of that is strictly liable. They did not do enough to protect others from that dangerous animal, so they can be sued fairly easily. Now, there is going to be some other examples that I want to give you. One is called a toxic tort, What this refers to is back really in the turn of the century, the late 1800s and the early 1900s, as the United States is beginning to really fully industrialize, we had factories and plants that were producing some very nasty chemicals that were difficult to deal with. During that time period, even up into the mid 1900s, these companies were simply just taking their chemicals and just pouring them into rivers. Now, I'm sure that you guys can understand just how dangerous that is, especially for the people who are downstream from this, as it can lead to some very serious medical issues. Now, in the 1950s and the 1960s, 1970s, this starts to get cleaned up, but it's still going to be at least somewhat of a problem, because trying to curtail all of these chemicals that might be dangerous from finding their way into water sources can be a difficult job. So a company that's found liable for putting almost any level of chemical into a water source can be found guilty and can have to pay huge amounts of money in damages to people who were affected by this. So the biggest government agency that we have now is the EPA, the Environmental Protection Agency. They have thousands upon thousands of employees and an enormous budget to protect against things like this. And they have a huge amount of regulatory power as well. They can fine companies who are found liable for these toxic chemicals being in a water source. They can take away their business license. They can shut them down. They can charge them enormous fines for what they might have done, no matter really how small it might be. Now, the last one that we're going to talk about are defective products. Now, I'm sure that you've probably seen this before, where a company issues a recall. A lot of times it's car companies where they say, we've determined that there's something about our car, our product, that is not safe for the public, and we have to recall that item. So you might have seen it in that recalling an item is just going to be, we need to bring it back into the company. We need to basically repossess it to fix the problem, and then make the person who bought that product whole again. We need to give them we need to basically either give them a new, safer product or refund the money from the product that was recalled. Now, I use this example because this came up a few years ago, where the Samsung manufacturer had a particular series of their Galaxy phone that had this very strange kind of battery problem, in that the battery was exploding in people's pockets. This can cause serious injury and death if in certain circumstances. But what really got Samsung in trouble here is someone brought their phone on an airplane and the battery exploded in the airplane. This can be a huge risk, and that company is going to be sued. And I forget the settlement they came up with, but they had to pay huge amounts of money in order to fix the problem and to make whole the people that were injured by this. Now, defective products can run the gamut. There can be all sorts of different kinds of defective products, and if found liable, that company is going to pay to make their customers whole again. Now, I do need to say, this will be the last of this lecture series on the civil or tort law.